Share employee legal relationships. Article 7 of the Opinions of the Ministry of Labor on several issues concerning the implementation of the Labor Law of the People's Republic of China stipulates that employers should sign labor contracts with their long-term employees who have been borrowed from other companies, paid school employees, and other employees who are not on the job but still maintain labor relations. However, during the period of loan and school attendance, certain relevant provisions in the labor contract can be changed through negotiation between the two parties. Sharing employees is essentially a legal relationship of personnel borrowing, and the labor relationship is still between the original unit and employees. Shared office is similar to the traditional labor dispatch mode, but it differs in terms of salary payment form, qualification, employment scale, etc. It can be considered as a short-term change in the labor contract, including work location, job position, and work content. The shared employment model does not belong to the legal relationship of labor dispatch, nor does it belong to a two-level labor relationship. As long as the employer has not issued a written notice of termination, dismissal, or decision to the employee during the duration of the labor relationship between the employer, supplier, and the employee still exists. Judging from the form, the current nature of the relationship between employers and these employees should only be a labor relationship. How to protect the relevant rights and interests of employees. 1. Payroll. Due to the similarity between the shared employment model and the legal relationship of labor dispatch, with reference to the legal provisions of the above labor dispatch relationship, the employer should pay the shared employees based on the principle of equal pay for equal work. For employers where the lending unit, supplier, is still a shared employee, the borrowing unit pays the salary to the employer, and then the employer pays it, making it more compliant. Of course, if the three parties reach an agreement, it can also be directly distributed by the borrowing company to shared employees. Sharing employees will directly change the employee's job position, work location, work content, salary, and treatment, which is a change in the labor contract. Therefore, the supplier should fully negotiate with the employee, inform the employee of the relevant work content, job responsibilities, salary, and treatment, seek the employee's opinions, and obtain the employee's consent. After the expiration of the cooperation period or the completion of the cooperation business, the sharing employee returns to the supply enterprise and continues with the original work. If the worker is unwilling to become a shared employee in the borrowing unit, she should accept the payment of wages from the supply enterprise at the time of shutdown, that is, within the first wage payment cycle. The payment should be made according to the standards agreed in the original labor contract. If the payment cycle exceeds 1, the salary can be paid according to the labor provided by the worker, according to the newly agreed standards between the two parties, but not less than the minimum wage standard in this city. If the employer does not arrange for workers to work, it shall pay the basic living expenses of the workers at a rate not lower than 70% of the minimum wage standard in this city. 2. Benefits such as individual income tax payment and 5 insurances and 1 fund. As a withholding agent for shared employees, a supply enterprise should normally list and deduct salary expenses before corporate income tax based on the facts. Individual income tax is withheld and remitted according to salary income for shared employees. Under the shared employment mode, the shared employee still has a labor relationship with the supply enterprise, and the corresponding labor employment risks are still borne by the original work unit, which should continue to pay benefits such as 5 insurances and 1 fund for the employee. The labor remuneration paid by the actual employment enterprise to the sharing employee shall include the social insurance part, and shall be paid by the employer where the employee belongs. Supply enterprises and demand enterprises can reasonably share social security expenses through agreement. 3. Definition of industrial injury. Article 43(3) of the Regulations on Industrial Injury Insurance stipulates, if an employee is injured by an industrial injury accident during the period of being seconded, the original employer shall bear the liability for industrial injury insurance, but the original employer and the seconded unit may agree on compensation methods. Therefore, if a shared employee suffers work-related injuries during the employment period, the supplier unit shall be responsible for declaring the work-related injuries and bearing the work-related injury insurance liability. If the supply unit and the employment demand unit agree on compensation measures for work-related injury liability, the agreement may be followed, but it shall not detract from the interests of the injured employee. For employees infected with COVID-19 during the employment period, if they meet the conditions identified as work-related injuries in the Notice on Medical Care and Related Workers with Novel Coronavirus Infection due to performance of work duties, they can enjoy work-related injury insurance benefits. If they do not meet the conditions, they can also have wage protection during the treatment period. However, there is still a risk that the workplace of shared employees is not the employer that pays Social Security for them, and special circumstances may arise where the workplace is separated from its normal workplace, which may affect the definition of work-related injuries. In order to prevent this risk and provide personal security for employees, it is recommended that the employers purchase commercial accident insurance for shared employees, such as employer liability insurance and COVID-19 special insurance. How to deduct enterprise income tax? Due to the labor relationship between the supplier and the employee, the wages and salaries paid to the employee are allowed to be deducted before tax. The required information includes a detailed salary list, the text of the labor contract, agreement, a full declaration certificate for personal income, and a certificate for withholding and paying personal income tax. Due to the fact that the employer has not signed a labor contract with the shared employee and has not established a labor relationship in law, the labor remuneration paid to the employer does not fall within the scope of reasonable wages and salaries referred to in the tax law. If the conditions for pre-tax deduction of wages and salaries are not met, the enterprise should obtain a legal instrument for pre-tax deduction. Employment demand enterprises can obtain their identity certificates, sign labor contracts or agreements, and apply to the tax authorities for the issuance of labor fee invoices based on the labor remuneration paid to them, which can be used as evidence for the pre-tax deduction of labor fees. How to sign a contract for sharing employees? A written agreement should be signed between the demander and the worker through consultation. If necessary, a tripartite agreement should be signed by the demander, the worker, and the supplier to clarify the rights and obligations between the three parties. Suppliers and demanders can sign cooperation agreements at the enterprise level. The agreement between the employer and the employee needs to clearly stipulate the nature of the contract, the number of employees, the term of employment, the job position, work content, job requirements, training arrangements, labor remuneration and payment, labor protection, exit mechanism, and other matters, as well as the legal risks and responsibilities of both parties. Demander enterprises should comply with the mandatory provisions of the law to legally employ workers, conduct necessary pre-job training, and pay attention to whether the physical, health, and abilities of employees meet the job requirements. Based on the situation of COVID-19 prevention and control, it is necessary to provide employees with corresponding labor protection equipment and working conditions in strict accordance with national and local government requirements. In terms of rest and vacation, mandatory provisions of the law should also be observed, and overtime pay should be paid while ensuring the right of workers to rest. For shared employees, it is necessary to verify with the supplier's enterprise the work arrangements during the shutdown period, the loan period, wages, and other conditions. It is necessary to verify the rights and obligations between the construction period and the employer's enterprise, and safeguard its legitimate rights and interests. Who is the subject of litigation in case of labor disputes? The supply enterprise has not terminated the labor contract with the employee, and the employee's labor relationship remains in the original unit. Employment demand enterprises only sign labor contracts with shared employees. Therefore, labor disputes or industrial accidents involving workers should be handled by the supply industry that has a labor contract relationship with the employee. The employee will still use the supply enterprise as the employer for labor arbitration or litigation.